I was in Coimbatore, and the scenario was like this: the COVID period saw a very difficult phase of life for all the service providers, particularly the hotels and restaurants. They had a tough time because most of the travel was closed and tourism was closed. Even visit to religious places have to be closed. That is the kind of spell, and that kind of scenario, the initiation of CIRP against hotel property. Then at that time, as the discussions went about, we were talking to the NCLT in hearings and telling them that this is likely to be settled. We're going to get some so many crores of rupees, 70 crores of funds and all these things. Ultimately, when the proposals were about to fructify, we had the decision of Supreme Court in EBIC Singapore. Supreme Court made a decision which is very, as a matter of practice, we may lose a case, but we always appreciate the law. We always appreciate the justice. The jurisprudence must be subserved and justice should be able to uphold it. So we are also having two dimensions. When you deal with your client, you approach it for the client's purposes. At the same time, when you look at the law and the decisions, we also appreciate that yes, this is how it should have been. So that two dimensions we should always have. And EBIC Singapore came as a villain of peace because Supreme Court said after submission of a resolution plan with the committee of creditors, and committee of creditors, let us say, approves it, and SRA is found, that is successful resolution applicant, thereafter files the resolution plan with the NCLT for approval, and NCLT takes its own time, the adjudicating authority. So when your resolution plan is chosen and a person has been, a resolution applicant has been identified and approved as a successful resolution applicant, there is some sort of binding nature of the resolution plan subject only to adjudicating authority clearing it under section 30. Therefore, a settlement cannot short-circuit this entire process. Entering into a settlement with a corporate debtor and COC will whole lot of things of the SRA, his programs, his corporate actions, mobilization of resources will all go to docs. And therefore, EBIC Singapore ruled that there cannot be any settlement of a case which is under CIRP after the resolution plan is approved by the COC, Committee of Creditors. So when I was about to submit the settlement plan for this client with some 260 crore proposal, as against the resolution plan which was returning to the creditors only 134 crores, though 134 crores gave them all their money including their claims. No creditor is left with any haircut. And yet that plan was at least half the size of the value of the property and the business. Unfortunately, EBIC Singapore came and it removed the chances of any settlement because by then when we offered the settlement, COC has already approved the resolution plan, SRA has come out, application is pending for resolution plan approval. So therefore what happens in these kind of scenarios is there is an intervention by judiciary which has removed the possibility of any settlement after that. Similarly, in the same matter, when the resolution plan was approved, it was found to be way below the liquidation value. The liquidation value as per RP was 203 crores. The resolution plan value was 134 crores with some 40 crores of preference shares to be redeemed after 20 years. And then came Maharashtra Seamless. Supreme Court said, there is no problem. Resolution plan can be less than liquidation value. As a result, Maharashtra Seamless spoiled the fortunes, whatever remaining, and put a lid of, we can say, the final nail on the coffin of the promoters of that corporate debtor. You can see in one resolution plan, one CIRP, two decisions of Supreme Court, finishing it once and for all. Now, the Amendment Act 2026 has come. That Amendment Act introduces a amendment to 12A which says no resolution, no settlement plan prior to constitution of Committee of Creditors. Because Committee of Creditors has to approve the settlement plan under 12A with a 90% majority. With a 90% majority. Maybe if you have time, just note down the decision of NCLAT, very recent decision, 6th April 2026 is an important thing. I am saying because all of us know 6th April is the date on which the Amendment Act was published in the Gazette of India. That is the same date on which NCLAT Delhi passes a judgment in CA number 247 of 2026 in the matter of Suyog Suryakant Talekar versus Triveni Mudrai project, NCLAT Delhi, 6th April 2026. In that decision, the NCLAT has very beautifully articulated the role of COC in approving a settlement plan under 12A. They say the COC is a trustee for all the creditors, all the stakeholders. You have to see a whole lot of factors, whether there is solvency, whether the balance sheet assets are more than what the liabilities and obligations are, whether anybody is going to be prejudicially affected by allowing it. Therefore, a whole lot of guidance factors have been given by NCLAT on the very same 6th April 2026 in this CA number 247 of 2026 with respect to how to go about in a settlement plan under 12A. In this perspective, you see the two different dimensions. The amendment comes. The amendment introduces two things. One, I will screen share and read it out for your benefit. One, the amendment says, I have straight gone to 12A. I will come back to some other provision little later. Subject to the subsection 2, the adjudicating authority may allow the withdrawal of an application admitted under 7, 9 or 10 with the approval of 90% voting share of the Committee of Creditors. Of course, we need to go to the CIRP regulations, regulation 30A. For the time being, let us not go there. Let us understand the amendment alone. Notwithstanding anything contained in any law for the time being in force, an application admitted under 7, 9, 10 shall not be withdrawn before the constitution of the Committee of Creditors. Therefore, prior to constitution of COC, there cannot be any settlement and withdrawal. Because there were cases, even I have argued before Delhi NCLAT at that time, NCLT, that constitution of Committee of Creditors itself has been dispensed with because of withdrawal applications and settlement. Now it is not possible. And the second thing is very important, that is 12A 2B. 12A is the section, subsection 2, clause B. After the first invitation for submission of resolution plan, after the invitation is given in EOI, expression of interest, prospective resolution applicants submit their interest, and now we filter the prospective resolution applicants, and we check whether they are hit by section 29A, and thereafter identifying the eligibility of the resolution applicant prospective, we select this, and thereafter we ask them to submit the resolution plan. Now you will understand, resolution plan, you are inviting somebody to bring a resolution plan. Such is the status when at that time one, there cannot be thereafter any settlement withdrawal application. It's a very interesting provision. It puts a timeline. No withdrawal prior to COC is constituted under 2021. Naturally, when COC is constituted, the NCLAT 6/4/2026 guidance factor will come into play. How COC has to apply its thought, not just like that. Secondly, once you are inviting a resolution plan from prospective resolution applicants, contradictorily, you can't discuss and allow a withdrawal application. That will put third party who are interested, who are mobilizing their resources, who spend their time and money and energy on understanding about the CD, that they will be put to difficulty. Therefore, this 12A is a welcome step. However, we have to understand it in a larger perspective. Let me give you an example of another matter where I appeared before the NCLT Chennai and asked for stay of the resolution process. Liquidation that time. CIRP has completed. It has not fetched any worthwhile results. Liquidation is ordered. And I go to the NCLT and say, like Withdrawal 1956 Act, you have power to stay the liquidation process. But the President's bench was there and President discarded the application and said, nothing doing, there is no power. 2023 August, that was the position. The NCLAT also agreed with that. That appeal is also gone. What is the effect of that? That there is no settlement or withdrawal at the liquidation stage. Once the liquidation commences, nobody can stop it. It will reach its logical conclusion is what is the decision. That was the decision where it was quoting some other decision in several cases. It was held that such a provision is not available. It is antithetical to the Insolvency and Bankruptcy Code. Very recently, probably you would have read, an OTS proposal was submitted by the suspended directors in NSL Nagapatnam roadways or some tollways or something case. It's an infra case in NCLT Hyderabad, where the NCLT Hyderabad rejected the settlement plan, even though the settlement plan offered more money to the kitty. More money is not the question. Integrity of the IBC process is the question. The value attached and the significance attached to that. And therefore, even after a time period has elapsed, if the suspended directors come back and say, I'll put or pour tons of money, no. Integrity of the process is upheld always, and therefore it is only difference or exception was, I remember there was an exception in R.C. Vallal Sterling Computer or some case which you may refer Supreme Court decision, and most recently there was a decision of NCLT in Maximus ARC versus Mummaneni Vajra case, NCLT Hyderabad, which is 6th March 2026. If you have time and if you are able to note it, kindly read this decision in Maximus ARC versus Mummaneni Vajra, NCLT Hyderabad, 6th March 2026. I will tell you what the para 27 says in that decision is. That was a case where this corporate debtor was a corporate guarantor. Since the CIRP is over and original amount is already recovered, no longer there is anything left to recover from corporate guarantor also. Therefore, corporate guarantor was as an exceptional case released from the rigours of the liquidation. In that case, it was a liquidation after CIRP. So, 12A amendment, which I have shown in the screen share, you can see there, notwithstanding anything contained in any law for the time being in force, no application shall be accepted, the withdrawal application shall be allowed before the constitution of COC and after the first invitation for submission of resolution plan. It's a very important provision which is going to be ruling the roost henceforth. So I started IBC with the settlement